Be ready. Start. This is an appeal filed under Section 62 of the Kerala Value Added Tax Act 2003, hereinafter called the Act Against Annexure 5, order issued by the Commissioner of Commercial Taxes under Section 94 of the Act, clarifying rate of tax on the products distributed by the appellant by name Ujala Supreme and Ujala Stiff and Shine. The products are manufactured by Mrs. Jyoti Laboratories, and appellant is the wholesale distributor of the products in Kerala. While Ujala Supreme is a fabric whitener, Ujala Stiff and Shine is a liquid fabric stiffener. The product samples produced by the appellant in bottles contain the description of the products. When the appellant applied for clarification before the Commissioner of Commercial Taxes on the rate of tax applicable to the above two products, the Commissioner clarified that both the products would fall under Entry 27 of Notification SRO 82/2006 dated 21/1/2006, issued under Section 61D of the Act, which is as follows. Detergents, whether cake, liquid, or powder, toilet soap, washing soap, laundry brighteners, stain busters, stain removers, and all kinds of cleaning powder and liquids, including floor and toilet cleaning. Essentially, the finding of the Commissioner was that since the items were used for imparting brightness and stiffness to clothes, those are laundry brighteners falling under Entry 27 above stated. Several documents, including test reports, decisions of the Central Excise Tribunal, etc., were produced to substantiate the contention of the appellant that the products are covered by the two entries of third schedule stated above. This court, after hearing parties' wide judgment in OTA number 13 of 2006, set aside the order of the Commissioner and remanded the matter back to the Commissioner for fresh consideration. The Commissioner, after considering all the materials furnished by the appellant and after hearing them, issued Annexure 5 order again clarifying that both the items do not fall under the above stated entries in the third schedule, and instead the items would fall under residuary entry 103 of SRO 82/2006, taxable at the rate of 12.5%. The only deviation made in Annexure 5 order from the earlier order of the Commissioner is that though he found that laundry brighteners are among the items covered by the heading of Entry 27 in Notification SRO 82/2006, no such item is provided in any of the subheadings with the HSN code number. The Commissioner therefore held that both the items fall under the residuary entry of 103 of SRO 82/2006, which provides for rate of tax on items not covered by any of the entries in the list provided in the notification or by any entry of any of the schedules to the Act. Accordingly, appellants claim that the item fall under the two entries of third schedule referred above was turned down by the Commissioner. It is against this order the appellant has filed this appeal. We have heard counsel appearing for the appellant and special government pleader appearing for the respondent. As already stated, Ujala Supreme is a product in liquid form sold in bottles for use as a fabric whitener. Appellant's main contention is that notification, namely SRO 82/2006, issued under Section 6 of the Act, cannot cover any goods specifically covered by second or third schedule to the Act, which attracts tax at the rate provided therein by virtue of Section 6 of the Act. We do not think there can be any dispute on this proposition because Section 6 itself expressly gives authority to the state government to issue notification providing for rate of tax at 12.5% only on goods not falling under Section 6 of the Act. However, the question to be considered is whether the two items are covered by the specific entries of the third schedule claimed by the appellant. Since the items involved are different though use is similar, we consider the items separately and serially hereunder. Ujala Supreme, the appellant's claim is that the item falls under entry 1558D of the third schedule with the HSN code number 3204-1294, which covers acid violates. We have to therefore consider whether Ujala Supreme sold by the appellant is an acid violate falling under the said entry, and if so, it cannot be treated as covered by notification issued under Section 61D of the Act. Appellant's case is that Ujala Supreme is made by the manufacturer, namely Jyoti Laboratories, by just diluting acid violet paste with water. They have produced test reports Annexure 7 and 8 issued by SGS India Private Limited, which shows that on analysis of the product, namely Ujala Supreme, the presence of AV49, that is acid violet paste, is only less than 1% and balance 99 is water. Annexure 9 is the test report of the acid violet paste and Ujala Supreme obtained by the appellant from the Institute of Chemical Technology, Mumbai, wherein they have stated as follows. The acid violet paste in bracket referred as AVP hereafter supplied to us conforms to acid violet 49, a synthetic dye classified into acid dye class, which is used for the coloration of silk wool at elevated temperatures in the presence of acid. AVP is uniform and having standard strength, which is formulated and prepared as ready for use. The AVP as well as Ujala purchased from the market are subjected to instrumental analysis and the results are observed. The diluted acid blue violet dyes are being used in the fabric finishing industries for imparting brightness to white fabrics. As such, Ujala cannot be used as a dye or a coloring matters, as it is because the fundamental principles of acid class of dyes is that they do not show any substantivity to the cotton and at the most they tint the fabric. Entry 155 falls under List A of third schedule to the Act covering industrial inputs and packing materials. It is obvious from the group heading of the schedule that all items given thereunder, including acid violet and falling under entry 155 8D, are essentially industrial inputs. The next question to be considered is whether the Commissioner is justified in classifying the item under entry 103 of the notification SRO 82/2006. Appellant has no case that the item falls under any of the entries of second or third schedule other than entry 155.80 of the third schedule which we found against. Since the item falls outside second or third schedule, rate of tax can be prescribed by the government in terms of section 6 of the act. The only notification issued in the regard is SRO 82/2006, which is entry 27, provides for rate of tax for fabrics whiteners. We have found that appellant did not deny that the only purpose of the item, namely Ujala Supreme, is for use as fabric whitener. However, even though Commissioner initially held that the item is a fabric whitener coming under entry 27, after remand by this court, he found that even though the group heading contains fabric whitener, none of the sub-entries covers fabric whitener. Therefore, the commissioner held that the item fall under residuary entry, namely entry 103 of SRO 82/2006. We are in complete agreement with this finding of the commissioner because entry 103 is a residuary entry covering item which are not covered by any of the entries in second or third schedule or any of the specific entries in the said notification. We therefore uphold Annexure 5 order of the Commissioner of Commercial Taxes on this issue. Stop.